Good evening. Welcome to the fourth session of the Legal English webinar series. Tonight, I am substituting Dr. Sofia Barinova. I am a practicing lawyer. My name is Sergey Fedorov. I am practicing in Russia, but I have a US LLM degree. My experience is over 20 years. My main area of expertise is corporate and M&A. We are looking forward to another spectacular session by Daniel. The session will have some questions. If you would like to ask questions during the presentation, you can use Telegram or you can use the comment section on YouTube. For the YouTube option, you need to be subscribed to our YouTube channel. During the presentation, as I mentioned, Daniel will also ask questions from time to time. For that, you can also use YouTube, or you can answer the question directly in the online presentation, for which you've got a link just before the presentation in your email. The presentation will last for about 90 minutes, so plan accordingly. Kindly ask your kids and pets not to disturb you during this period of time, because we are going to have another spectacular session by Daniel. Now I'm giving the floor over to Daniel. Daniel, good evening.
Good evening, Sergey, and I'm delighted to be hosting with you this evening. And we had a chat beforehand, and Sergey knows corporate law and M&A, and that's my weak spot. But property law is something where this is a strength of mine, and this is something that he's interested in learning about. So I'm delighted to have this exchange this evening. I'm also delighted to have someone who has an LLM, which is, as we know, it is a degree that I don't have because I have a JD, and normally when you have a JD, you don't get an LLM afterwards. So we have two different perspectives coming in our webinar tonight. We have Sergey as a foreign lawyer and English speaker with an LLM, and myself as a native English speaker with a JD. So I will be very interested to hear Sergey's observations on what I present in property law. And as I was also saying to Sergey, it seems like everyone that watches likes the difficult problems that we have in common law. So tonight, I've made it very difficult for everyone. So I'm looking forward to challenging you. And property law does present a lot of challenges. So moving on. Moving on, we first want to say thanks to the Relo for Russia, Jennifer Uller, and also to Sophia, who is going to be substituted very ably by Sergey this evening. Now, property law. So we did property rental last week. I'm now interested in what words you know related to selling property, buying and selling property. So you can write in the YouTube chat. You can write on Telegram. If you want to write directly into my presentation, I see a number of you have already logged on. I would like to hear your vocabulary ideas. And while we're waiting for that information, there are certain countries where people rent, and there are certain countries where people like to buy. Sergey, what would you say in Russia? Do people enjoy renting or buying property?
I think people prefer buying, of course, if they have enough finance. But the problem is that real estate is very expensive, so people do not have enough money immediately. So they need to use loans from the banks usually. And the banks are demanding. They need to see a particular level of income, that you have a stable job, or they sometimes ask for security because they need to be sure that the loan will be repaid.
So there's a lot of mortgage is happening in Russia.
Yes.
And you know, this is another thing. I've always talking about the things that we have in common, and this is another thing. So in America, in the UK, everybody wants to own like they do in Russia, but most people don't have the money, so they're going to the bank, they're getting a loan, they're getting a mortgage. And, you know, sometimes people are worried, can I pay my mortgage this month? And that is definitely a stress that many people who have bought a house with a mortgage or a flat with a mortgage have these days. So do we have any property words so far, Sergey, from?
Yes, on YouTube, the answers are repossess, title, property deed, agreement.
Okay, I like repossess. We will be talking about something similar to that. A deed, yes, that is the you have to pass the deed from the seller to the buyer. Let's see, on the presentation, I have the word compliance. Now that's an interesting word. I'd be very curious to hear how you would insert that in a property context, Anastasia. It certainly does have a relevance. Property particulars, Mariana has put, and I love that because it's a very British phrase. The property particulars. You would never hear that in America. You would say the details of the property, the features of the property. But in British English, which we know is a sometimes completely different than American English, we would talk about the property particulars. Excellent. I see mortgage. Lubov says mortgage. So thank you for those words coming in. Any more words, Sergey, from any of our channels?
Tenants, specifications.
I like specifications. That's another word I think would be good for either America or the UK, the specifications. So, you know, when we're talking about how large or small the property is, what features it has, nice. Any more? Last call for vocabulary. I'm going to check mine too. Any more?
Contract terms, buy off plan.
Can you repeat that? I didn't hear that one.
Contract terms, buy off plan.
Okay.
Listed property.
Okay. Yes. So in essence, you need to have a contract to sell and buy a property. So yes, what we're going to be talking about is this idea of passing the property from the buyer to the seller via a sales contract or a sales agreement. And as we have previously discussed with Sophia, in the larger context, we are all of our sessions this term are related to contracts. And obviously in the area of property, there are special types of contracts, but contracts are extremely relevant. Okay, thank you for those contributions. Now, again, I love to learn about what happens in your country. So I'm wondering about selling a property in Russia, a flat, a house, a piece of land. What is the selling process like? And what difficulties tend to happen when you sell property? So if you could write in Telegram or in YouTube, and while we're waiting for that, Sergey, so what is your answer to these two questions?
My answer is that the process of selling real estate in Russia is very bureaucratic, because to get the title transferred, you need to register the transfer of title with a special state authority. So first, the parties sign a written contract, which is then registered with a special authority. And the registration process relates to the registration of the title property. Before that, previously under the previous legislation, even the contracts were to be registered by the same authority. Now we left this practice, so the contract itself is not registered anymore, but the title transfer should be registered. And of course, the state authority monitors the situation with the property. It reviews very thoroughly the contracts before registering the title transfer.
Okay, So I'm already seeing a commonality here. Yes, and as you said, our situation is very similar with the one that is in Russia currently. So we would not register any contracts, but the changing of the deed needs to go to the registry office in the UK, or the registrar, sometimes they call it in the US, but there will be a specific office where you need to change the names on the deed of the property. It's not necessarily that bureaucratic. You just go and you change the names. It's a fairly standard process. But yes, that is exactly the same. What about difficulties with selling property? What is the most, if I wanted to buy or sell in Russia, what are the biggest problems that I would have in that respect?
I would say that the biggest problems are in the area of buildings and bigger real estate structures, not apartments, because apartment is in the bigger object, real estate object. It's just a part of it, but the building is on a land plot. And under Russian law, you cannot sell a building without a land plot. So you need to transfer the rights to the land plot as well. If you own it, you need to transfer the title. If you lease it, you need to transfer the rights to lease the land plot. And I think in practice, the most problems come from this.
And why is that?
Because we have a long history of ownership, which changed. During Soviet times, people and companies couldn't own land. It belonged to a state. Then the situation changed, and companies and private persons began to own the land. So there are still a lot of land plots which are leased by state to private persons and companies. And the legislation also changes from time to time, trying to keep track with practice. And there are still some old ownerships to land plots and some strange rights which do not exist anymore under the modern legislation, but still exist under the documents. And also we have a history of privatization when the state ownership transferred to private ownership. There is a mess with such cases because the documents are difficult. There are a lot of court disputes, and recently we have a row of disputes with respect to the results of the privatization. So when you buy a building, you do not know which problems you will encounter because you do not even know the history of the land plot, which can come back like decades ago.
I see. So that may come back to haunt you.
Yes.
Oh, okay. Well, Sergey has a look at Telegram and YouTube. I'm going to make a comparison with what he has summarized. And I would say it sounds like the situation in Russia is more similar to the British situation. Because remember, in the UK, there was a time when the crown, the king and the queen, owned all the land. And that was partitioned off. And if you were here with me last year at this time, we learned that you can actually, some properties you cannot buy. You have to buy a lease to the property for 150 years, 175 years, how many years. And it relates to the fact that there are properties which the crown owns and has given away to someone for 1,000 years, and then that person subdivided it and gave shorter and shorter and shorter leases. So we have that same complexity in the UK. In the US, it is very simple. You buy your flat, you buy your house, you buy the building. So we don't have those issues. And I think probably throughout Europe, the property is very complex. Because you've had such a long history, and as it is in Russia. So, Sergey, what are we hearing from Telegram and YouTube?
Yeah, we see a lot of interesting information. The viewers really go deep. For example, I mentioned a written form of an agreement which goes for the registration during the process of selling the real estate property. And I didn't mention that nowadays the written form is signed online. So formally, it is still a written form, but the agreements are signed online and sent to the registration authority via internet. Also, the problems during this the selling process is individuals dislike using realtor on second market. The deal needs verified by notary. Indeed,
Okay.
I didn't mention it, but some of the agreements, although they do not need registration anymore, but some of them need notarization. So
Okay.
the parties go to a notary public who notarizes the written agreement and then sends it electronically for registration.
I see.
The agreement should contain consent from the third party, is one of the issues in practice.
Okay.
When you wish to purchase an old apartment, there is a great deal of risk since occasionally we withhold information and the seller tries to conceal paperwork.
Wow. Oh, okay.
Based on some viewers' experience, you cannot purchase property without a real estate agent, basically. So there is a different approach to using realtors.
So what is it? Is it expensive to use a real estate agent or an estate agent in Russia? Does that add to the expense of the seller and the buyer?
It depends. I do not encounter real estate agents much, but I believe that there is a percentage commission for their work.
Okay.
So basically, you should consider for which price you would like to sell the real estate property in order to cover the real estate agent expenses.
I see. I see.
But I believe that there is a fixed price scheme of work as well.
Oh, okay. Interesting. I would say in the UK and the US, most all people go through a real estate agent only because the real estate agent is sort of like a quasi specialist in terms of property law, and they know what checks that you need to get and what the sequence of of the sale, because there are certain parts of the sale you have a deposit, then you have the closing, and they take care of a lot of things. When the keys are delivered, they're not delivered. They're usually delivered to the estate agent or the realtor, and you pick them up at the realtors. So this is really common. However, there are movements. Sometimes there are sites that you can go on and you can just sell your property on your own. But sometimes these people have a problem because they've missed some legal requirement or a legal check. For example, in the UK, there's a new regulation that a seller has to give the buyer an energy certificate, okay, to show the property, electricity certificate to show that the property is fine, the electricity is fine, and that there are no problems. So that is a new thing that has to be in the pack. We call it the seller's pack of information. And this is also quite complex because property is not something in the US, which is a national thing. So it's not regulated by the federal government. Each state government is entitled to have its own property laws. So then you would, if you were buying and selling in Pennsylvania, for example, you would have to look to that Pennsylvania law to see what is required of a sale. So it is, there are 50 different property law regimes for selling property in the US. So this is a very complicated area of law for many reasons.
From the YouTube, sorry, Daniel?
Go ahead. Is there any more on this subject? from
I see the prices from YouTube. People say it's 4% or 10%, from 2 to 4%, depending on property costs. So I would say it's not expensive, considering that real estate is very expensive. If you do not use real estate agent or at least a lawyer, the risks are high. So I would say it's worth using real estate agent or a lawyer for buying a real estate property.
And I think from what I remember, the rates are higher here. I think it's more in the 10% region, but prices are very high. We have obviously here in London, prices are just ridiculously high, as they are in Russia. But I will have to say, in my hometown in Pennsylvania, you can get a whole house for very little money. So, you know, prices really, really wildly fluctuate in common law jurisdictions, depending on where you are. Okay, thank you for everybody who contributed to that. Let's move on now to what is typical in a property sales contract. Now, as I said before, each state, if we're looking at American law, and we will be for the rest of the day with maybe some comparisons to British law, each state is entitled to make its own laws about property, because the idea behind this is the federal government cannot say that the property conditions are the same in New York, which is a very urban state, as opposed to Montana, which is a very rural state. So each of these states, the legislators are entitled to make laws that are particular to their citizens. However, there are some basic provisions that any property law contract for sale should have. These include, first, we have to say who the buyer and seller are. Second, we have to have a detailed description of the property. And then we have to talk about the price and the manner of payment. Usually, in common law jurisdictions, when you first make the offer is accepted, you would put a deposit down of maybe 10 to 15%. And then at closing, the rest of the payment would be due.
Daniel, can I interrupt you?
Yes.
Maybe we should elaborate on the term closing, because we do not have such a concept in Russia.
Okay, so closing is a big day. It's called closing day. And that is when the property officially transfers from the seller to the buyer. And this is after there are many checks. So if we look at the sequence of property, I make an offer, the seller accepts. Then as the buyer, I go in and I'm entitled to inspect the property. Usually there's a surveyor that comes in to make sure that the structure is sound. There are other checks, and there's other information that I can ask of the seller. And
so first, sorry, yeah, go ahead. So first, the parties sign a contract which sets forth what the parties should do before closing, preparing some documents, some checks. Then the procedure of closing is also described. It is the obligation of the parties to close, and then they follow this procedure prescribed in the contract, and they conduct the closing, right?
Yes. So there will be a date nominated for closing, and on that day, what will happen is that the buyer will transfer the rest of the money. So if the buyer paid a deposit of 10%, the rest, there's a long list of charges, and then the buyer will transfer the rest of the money that is due. So 90%, there may be other costs and charges which will affect the final price. And this will be done by, for example, a certified check, not just a check, a certified check or bank transfer. Then the buyer, once that the seller's lawyer, usually lawyer confirms to the seller the money has been transferred, the keys will be released. So the buyer will go to the realtor or the lawyer to pick up the keys for the property, and the buyer now officially owns the property. So that is a big day. And sometimes if there's a problem with the property, that day may be moved, and it's considered to be a very stressful situation, because sometimes, for example, you make an agreement and then they discover that there's a problem with the survey and the property, something is falling down, and then you have to go back to the seller and maybe renegotiate a discount, or the contract will change because the property is now maybe not fit for habitation, something like to talk about a term that we used in the leasing. So that is a really big day, and it's very nerve-wracking, we would say. People don't sleep the night before closing usually.
So summarizing, closing is a performance of the contract, sales contract, right? It's the finish of the performance.
Yes, Sergey, that's an excellent way to summarize it. Yes, it is the performance of the contract. Buyer is now the official owner of the house. The seller has no more rights to it, and that's usually, and this closing can be delayed. It can be weeks. Usually it takes about, it could take up to like months and months to get all of the documents that are needed, and to go and to make sure that if the buyer has questions about the property, the seller answers them. So closing could take months and months, and it is movable, but it is the day when the contract is performed. Very, very well said.
Do you use a term escrow agent for keeping the keys? You mentioned that some persons keep the keys. Do you use the same term as for keeping the money?
Not really, because it's literally on the day the money is transferred, and then the keys are given. So the idea is it's supposed to be a simultaneous act. And I remember we had one situation with a client. They said, "Oh, if you give us the money, then we'll give you the key the next day." And we said, "No, it has to be on the same day." And this is again, this is something that is very, very important, that the money and the keys will be exchanged on the same day. And this is supervised by the lawyers on the buyers and the sellers side.
On YouTube, I see that some people mention letter of credit. We call it accreditive in Russian. Is it popular to be used in the UK or US?
So there are two ways essentially that you would transfer property. The first one is by a certified check, and the idea of a certified check is this is guaranteed, or a banker's draft. Okay, a banker's draft. Okay, so these would be, there is, instead of, because obviously we could write a check and the check could bounce. Mm-hmm. So there is a sort of a higher level of check called a certified check or a banker's draft. Those are the things that are the most common. Sometimes there is a direct transfer of money, not really a letter of credit. That is for other purposes.
Are we talking about individuals, or are we also talking about companies who use checks, not letters of credit or escrows?
Yeah, I'm not sure. I mostly deal with the private individuals buying property. So this might be a question for a corporate lawyer. I would rather not give an answer because I'm not sure about that particular aspect of it.
Okay, thank you.
Okay, so to move on, and thank you for all your questions and your inquisitiveness. As we said, the deposit is important. It will say how much money, usually between 10 and 15% is the deposit. The contract will also talk about financing. As we said, in Russia, you often have a mortgage, and most property is bought with a mortgage. You could assume a mortgage if you're a buyer. This will all be in this agreement. And obviously, you have to write down and sign the property agreement. It's one of those contracts. Some contracts do not need to be signed. This one needs to be signed. And that makes sense. Now, these are general provisions. If you, again, are dealing with property in New York City, you would have to look at the law of the state of New York as to if there are any other requirements, because as Sergey and I were talking about earlier, case law is very active in the property realm. So case law may determine, or regulations may determine, that there are other essential requirements that selling property in a particular state will have. For example, New York may have it, but if you go to Pennsylvania, there may be other requirements depending on laws, regulations, and also case law. So this is why people often use a estate agent or a realtor, because these people are up on all of the latest changes. And then they also have a lawyer too, who deals with the more legal aspects of the property. So you'll have your estate agent and your lawyer on each side. So a lot of people are involved in a sale of a property. Okay, how are we doing? Any more questions about?
Yes, we still have questions about paying. One of the questions is installment sales. Is it a common way or not?
No.
So it's a lump sum.
Yeah, it's a lump sum. So there's the lump sum as a deposit, and then the final sum. Yeah, that's an interesting concept, but I've never seen that.
Another question is, if you assume the previous owner's mortgage, do you pay them the amount of their equity and then continue with the regular mortgage payments?
Yeah, that's going to depend on the mortgage agreement. So that's going to be something that's very specific to the actual mortgage agreement with the bank and what the buyer and the seller negotiate. Okay, great questions. Again, very high level, challenging, and don't worry, I have some great challenges ahead. Okay, the first one. So this is my tricky question here. I made it tricky because I know that everybody likes a challenge who follows these webinars. So my question is, I have 4 provisions here. And my question is, which of those would you not find in a sales contract, in a property sales contract? So first one, a clause stating the exact amount of the deposit, a covenant restricting the use of the property, a term specifying how the money due at closing will be paid, or a provision allowing the buyer to inspect the property at any time before closing. So this is a hard one. I have some difficult vocabulary. Sergey, is there any vocabulary that you would like me to discuss that you think may pose a challenge?
I think everything is clear. Covenant you probably discussed during the previous sessions, right?
We did not.
You did not.
We did not. Okay. No, we didn't. So in this case, a restricted covenant is merely a provision. Okay. So I'll give you a great example of the building that I live in. No, I'm going to wait. I'm going to wait on that. I will give you that example, but I'm going to give you a little bit later. But the covenant is a nice word for a provision or a term. Now I'm seeing that one person, there was someone who suggested that a covenant restricting the use of property would not be in a sales contract, and that makes a lot of sense. How about the people on YouTube and Telegram, what are they saying would not be in a sales contract?
4 answers number 2 and 1 answer the last one.
Okay, so we have number 2 and the last one.
And I have another answer which gives 2 answers, 2 and 4.
Okay, so what's happening is both. Okay. So let's deal with the easy ones. And if we get any more answers, please shout them out, Sergey. So nobody said the first one. And obviously you need to have the exact amount of the deposit. That is very important in your property sales contract, because then this is how you calculate the rest, the price at closing. Number 3, yes, the term specifying how the money is due. Yes, we have to have something really specific. And that will be detailed in the property sales contract. Now, so the question is would we never have a covenant restricting the use of the property, or would we never allow the buyer to inspect the property at any time before closing? Let's look at any more answers come in, Sergey?
One more answer, number 4.
Okay.
Another number 4.
Okay. So, and if you said number 4, you are right. Okay. So bravo.
Congratulations.
This is really complex. Okay. So I made this very tricky. So if you said number 4, you can give yourself a pat on the back. Now, the problem with number 4 is the buyer is allowed to inspect the property, but has to have the agreement of the seller. So when you're buying a property, yes, we want to inspect, but you just can't go at your leisure. You have to have the agreement and the permission of the seller, because you're technically going on to their property. If you don't have that agreement, you're trespassing. So that's what makes number 4 wrong. However, this covenant. So yes, you will have many covenants restricting the use of your property, which brings us to the topic of the day, restrictive covenants. Woo! Okay, so I'll be very curious to hear what the situation in Russia is, but in property sales in the US, in the UK, in any common law jurisdiction, it is very common in your deed, you will have a restrictive covenant saying, this is what you cannot do with the property. So, do we have such things in Russia?
Yes, I think we have this, but it is not from the agreement. It is from the statute. So it's a matter of law, even if the agreement doesn't mention it. For example, there are cases when a building is privatized and there is an encumbrance registered with this special authority, which registers real estate. Sometimes it says that the building or the premises couldn't be used for any other purpose than the one specified in the registry, because the building or the premise is a historic or cultural landmark. For example, historically, the premises were used a grocery store. So the state put a restriction. You cannot use these premises for anything else.
Okay.
So it is a kind of a restriction, but I would say it's an encumbrance following from law, not an agreement.
Okay. And we had those types of restrictions too. We have zoning restrictions. For example, you can't buy a residential home in an area and then turn it into a business, because it is a residential zone and not a business zone. And especially in the UK, the government has said there are certain houses, certain places you can't make alterations to because they are listed, or they have grade 1, grade 2, grade 2A, and these are special properties like castles and stately homes. So yeah, there are limitations. All of that said, even your standard block of flats may have a restrictive covenant. And now I will give you a great example of the building where I live. In my building, the deed is written so that they want to discourage people from hiring out the flats to Airbnb. Now, do Russians know the concept of Airbnb? Is this something you have in Russia?
No.
Okay.
I think we don't have alternatives. Airbnb doesn't work in Russia anymore.
Okay. So Airbnb is very popular. And it's, for example, in the area where I am, it's a tourist area. So you could buy a flat and do it up and then make lots of money from Airbnb. And the owners of these flats here in this building said, we don't want to have people going in and out and in and out. So in the deed to the flats in the building where I live, there is a restrictive covenant. And it says, if you rent out, you can rent out a year at a time. But after that year, the person has to move out. Now, and then the flat has to be left vacant for 1 year. So 1 year having a tenant, 1 year not having a tenant. They've also said that even if you rent the flat out for 1 or 2 days to someone like Airbnb, then you have to have the flat vacant for a year afterwards. So the idea is to discourage people from buying a flat and renting it out and lots of people coming and going in the building. And this is a great example of a restrictive covenant.
Interesting. But does it follow from the agreement or from the homeowners association?
Okay. So this is great because we have a case dealing with the homeowner situation. So when you have a block of flats and everyone has a freehold, and now we're dealing specifically in UK law here, the owners of the freehold as a group can elect to change the deed and the constitution of the building by majority vote. So I think it's 3/4 of owners have to vote. So they are voting this into the deed. Okay, so this covenant is a part of the deed that would be passed to anybody buying property in the building. Questions? Any questions at this point?
Yes, we have a question. How often is the notarial procedure for concluding the transaction used? Is the notary's deposit account used for settlements?
No, it's not at all. But you may have to note, again, depending on the state where you live, you may have to get a notary to notarize documents. And remember, I don't know how it is in Russia, but I've lived in countries where it's very hard to get a notary. It's hard to find a notary. It's hard to become a notary. It's hard to get something notarized. It's very easy to do so in the States as it is in the UK.
Yeah, in civil law jurisdictions, notary is a more important person than in common law jurisdictions, as I understand.
Yes, very much more important. Okay, shall we proceed to our first difficult problem about restrictive covenants?
Sure.
Okay, so we're going to look first at a New York example. And what I love about this New York example is that this text is coming from a case from 2021. Now, notice it says New York. I'll give anybody a big prize that can tell me why it's a slip opinion. But we'll save that. So if anybody wants to write in the chat why this is a slip opinion, the answer, that's fine, but I will move on with the explanation of the case. The wonderful thing about this case from 2021, not very long ago, is it is quoting conditions that were established in a case in 1938. Okay, So there is a three-part test for certain restrictive covenants that was established in 1938, and the court in 2021 is quoting that. This is a great example of judge-made common law that becomes part of the property law canon. So, and if you shepherdize this case, if you research the case to see the history, you see many other courts quoting the standards. So this is what I love about this case. What I love even more, and I just want to get I'm looking at my notes because I want to get the right person. These three rules about restrictive covenants were taken from a book, okay, a treatise, Clark on Covenants and Interests Running with the Land. So the judge looked into a legal scholar's book and took these three criteria, and then they became part of New York law when dealing with restrictive covenants. And this is, as Sergey and I were talking about earlier, this is a classic common law, judge-made law. You have to do your research if you are dealing with restrictive covenants to understand where this standard came from. And I find that quite interesting. Okay, that all said. Now, let's look at this three-pronged test. We call it three-pronged test that was established in Neponset. It's a very strange name in English. I don't know where this name comes from, but it's not what we would consider a normal name. So I think it's some sort of hybrid of two words. So for the covenant to run with the land, okay, so I love this phrase. To run with the land means to be passed from one owner to another. We need to have three things. First of all, intent. Now, notice here we talk about the grantor and the grantee. In this particular case, grantor and grantee mean the person originally giving the land to the buyer, okay? So the first purchaser of the land, basically. Number two, the covenant must touch the land, okay? So it must affect the land. It must be relevant to the land, as literally touching the land. Finally, there must be privity of estate. Okay, and again, this fancy word just means that two or more parties have an interest in the same property. You have privity of contract. Okay, these parties have a contract. Privity of estate is they're both concerned about the same property. So the promisee and promisor must have privity of estate. And why we have a difference between the grantor and the grantee and the promisee and the promisor is promisee and the promisor are somewhere down the chain. They're not the two original buyer. They are not the original buyer and seller of the property. So these are the three criteria. Are there any questions about those? Because then we're going to have a case.
No, I don't see any questions.
Okay, so let's look at a case. So this is the Neponset case that was quoted in a later case, Wilmot versus Ceric. Now, let's look now at the facts of the Neponset case and decide whether these three criteria were fulfilled. Again, we have lots of vocabulary here, so I'll go through and I will discuss each bit of vocabulary as it comes up. So there was a company and it created a residential development and sold tracts of land. So a tract is like a subdivision of land. So maybe they sold 100 different small tracts of lands to individuals. Now, this bank, Emigrant Industrial Savings Bank, they bought a tract of land through a judicial sale. What is the judicial sale? This is where somebody can't pay money to someone. Someone owes money to someone else. They can't pay it. The person attaches the debt to a particular property. The judge sells the property, and then the person who is owed the money gets the funds. So this was the 1930s, and this happened a lot because there was the Depression, people were very poor. They lost their property through a judicial sale because they owed money to lots of people, and then the judge sold the property, and then the money was distributed. So this is how the property came through it to Industrial Savings Bank. So it was not the original owner. Now, every deed in the conveyance chain, okay, so we talk about all the history of the buyers and sellers of the property is the conveyance chain. And obviously, there are in the UK, some of them can be very, very complex because of the history of property. You can have a conveyance chain going back to the 1500s, 1600s. It's much easier in the US where, property doesn't have that history as it has in the UK. Now, let's look at what every deed in that conveyance chain had this same provision, that the grantee, its heirs, successors, and assigns would pay some money, a maintenance fee, for the streets and public places to the grantor or the grantors, successors, and assigns, which may include a property owners association. Okay, so heirs, successors, and assigns. Heirs are your heirs in the will. A successor could be anybody that gets the property. So maybe one corporation succeeds another, and assigns means to give your rights to someone else. Now,
So successors, assigns, I would say, intentional transfer of rights and
yes,
delegation of duties under the contract. Successors is kind of universal succession, right?
yes, exactly. And heirs, I mean, you could have, for example, an heir usually would be, it's written in a will, the person that will succeed in the will. A successor, there are other options. And we talked about this idea of a property owners association. And in fact, Neponsit, once it created this residential development and sold tracts, it became a property owners association. So it basically transferred into this property owners association, and it was responsible for, in the UK, we would say, maintenance of the common parts. Okay, so the idea, this was like a development, and we would have a street, and there was, I think I read there was even a beach there, and they needed money to keep these things nice for all of the people who lived in this housing development. Okay. In terms of not paying this fee, it said in the deed that there would be a lien on the property. Okay, so a lien would, again, you would attach the property financially. If you didn't pay this fee, that the property would be attached financially. And what happened in this case is the immigrant refused to pay the fee. The lien was placed on the property, and then Neponsit thought to foreclose, to take the property back. Okay, and this is a synonym for repossess. Usually you say foreclose on property. With repossess, you would maybe repossess furniture or a car. So foreclose is the magic word for property. Okay, any questions from you, Sergey, or from any of our wonderful viewers? I know this is difficult, but I know you're up to the challenge, everyone.
No, there are no questions.
Okay, great. So the key question here, if we look at this covenant supporting foreclosure, does it satisfy the 3 criteria? So let's go back to the 3 criteria. Okay, so first one, Do we think that the grantor and grantee intended that the covenant should run with the land? I'll let you think about this and then we'll have a question. Does the covenant touch the land? Okay, because remember, this covenant is not about this particular property. It is about property surrounding the owner's property. The road on the property, the parks on the property, the beaches on the property. Doesn't touch this particular property. And again, is there privity as the state here? Because, you know, the Neponset is now not really the owner of the property. It is the owner of the common part. It is responsible for regulating the common parts, the beach, taking care of things. Is there privity of estate with this property in this particular situation? So these are the complex concepts that the court had to wrestle with. And so this is my question to you. So in your opinion, what do you think should be decided? What do you think that the court argued? Were the three criteria satisfied? All of them? Were none of the three criteria satisfied? Was there privity of estate? Or not? So does the covenant touch the land, but there's no privity of estate? Does the covenant not touch the land, although there is privity of estate? So there's a lot of different options here that we could have in this situation. And as Sergey and I were talking about earlier, this is the judge for to decide. So the judge had to look at these criteria, think about these things, and quite frankly, the judge could have come to any verdict, okay, as long as it was well argued. However, notice that this case from 1938 is still articulating the criteria. So many people thought this judge made a very good decision here because it is still the criteria for restrictive covenants. Okay, would anybody dare to answer which one they think is correct? I know this one's a difficult one. Some people may be very shy on this.
Yeah, the people are thinking.
Okay.
But the answers began to appear.
Okay, yes, I'm getting some answers too. I'm very delighted for your bravery.
No, the covenant doesn't. But I don't see which of the options it refers to.
Okay, on mine, I'm getting no's, and some people are saying the covenant does not touch the land, and others are saying there is no privity of estate. So no's, but for different reasons. Any other?
Yeah, number one, yes, the three criteria are satisfied. Another answer is none of three are satisfied.
Okay.
No, the covenant doesn't touch the land, probably. Initially, it looks like the three criteria are satisfied, but having a more comprehensive review, they aren't.
Okay.
Number three.
So we're all over the place. We have answers all over the place. This is great. This is great.
Number one, yes. Another yes. Number three.
Okay, thank you, Sergey. Okay, and again, the judge probably could have made a good argument for any of these options. But in this particular case, the judge said the three criteria are satisfied. Now, I'm going to look at my notes because I want to get the reasoning right. There was a massive discussion about whether the covenant runs with the land in terms of touching the land. And what the judge said was the common parts of the land, you know, the road to the house, to the development, the beaches and the parks are things that all the landowners would enjoy, including the person that owned this particular house. And it must be maintained. So according to this judge, it did touch the land if we go back to this criteria. I think we can make a good argument that the grantor and grantee intended that the covenant should run with the land because it was in every deed. If the covenant had been left out of one or two deeds, that would have been more problematic. But here, every deed says that has this covenant. They've also said that there is privity of estate here because public policy supports, and again, a public policy argument. So it is good public policy to support the idea of an association that is formed to meet property owners' needs, having privity of estate with all the property owners on the development. Now, some of you disagreed, and this judge could have said other things, but that is, in this particular case, that is how the legal reasoning worked. And this is something that a lot of other judges have said, yes, we agree, this was good reasoning. And in the case in 2001, they quoted this standard. So this is a standard that has held up because it is considered to be reasonable and good public policy. So entitled to foreclose, and it was only $4. They only had to pay $4. Well, obviously this is back in the 1930s. It was only $4 per term. So I think it was like a total of, you know, $12 or $16 for the whole year. But they did not want to pay it. Okay, but great thinking, great work. Okay, let's move on. This was our Everest. So now we're down on the other side of the mountain and something a little bit more fun. I'm going to talk about aesthetic
Daniel,
covenants.
before we are switching to aesthetic covenants, I have a question on
Yes.
Telegram, which is very interesting. Is restrictive covenant and negative covenant the same?
We don't say really negative covenant. Restrictive covenant means there is a restriction on the property. There is something that you cannot do. It is a negative concept because it is restricting the right of the owner. It is narrowing the right of the owner. So that's probably the best way to, but you would not say in property law, it is restrictive covenant rather than negative covenant, even though these words are very similar in general English.
Thank you.
Okay, aesthetic covenants. Aesthetic, is this a word that our viewers would know or require some explanation?
Yes, the Russian word is similar.
Okay. Oh, okay, great. Maybe we stole it from you. Maybe we stole it from you. Great. Okay, so aesthetic covenants are about the beauty of the property, and they require buyers to keep the property looking a certain way, or they require permission before the property is altered. Again, in the UK, you do have a lot of that because you have older properties and you want to keep them looking, the period detail looking nice. So there may be something that says this must be cleaned every year. You're required to do that. You're required to upkeep the Art Deco, or I can imagine on a property like this, there would be a lot of aesthetic covenants. So this makes sense. Let's move on to a sort of a more simple case now that we've crossed our Everests. So this is an aesthetic covenant scenario, and we're talking about Cheyenne Homes, and this is a case in Colorado. And we have another developer who made a subdivision. Okay, so they developed a tract of land into smaller tracts with a restrictive covenant. And this one said that you cannot build, place, alter any building on this lot unless it is approved by the Architectural Control Committee. So Cheyenne Homes established this Architectural Control Committee. Rue came in and they moved in a 30-year-old Spanish house. And I don't know, again, how you do things, whether this is common in Russia, but sometimes people will take a whole house and they will move it to another area. So this was a 30-year-old house. It was moved to this development. They did not ask the committee. The problem was the rest of the developments were modern ranch and split level homes. And Cheyenne was not happy. So they asked for an injunction against Rue. Now, let's go back. So would our viewers know the difference between a Spanish style, a modern ranch, and a split level home? Do you have
I believe so.
Sorry?
I believe so.
Okay, great. Great. I will say that in terms of a Spanish style house, you can tell this is a Western case because in the East Coast of the country, you would not have Spanish style houses. They're not common, but they are common in the South and the Southwest. This is a Colorado case. And injunction, that should be a word that we all have seen before. Do we need a refresh, Sergey, of that word?
Yes, it would be good.
Okay. So if you apply for an injunction, you ask the judge to order someone to stop doing something. So in this particular case, they applied for an injunction because they wanted that house out of there. They do not want a Spanish style house on their property. Now, interestingly, in this case, Cheyenne claimed that the purpose of the covenant was to protect the value of the property. So they're claiming if we have all of these modern ranch and split level homes and we move in this old ranch house, the value of the whole subdivision is going to go down. So that's a very interesting argument there. Okay, so do you think the judge said that this aesthetic covenant was valid or not? What do you think? So again, write in the presentation, write on YouTube. What do you think? This one is a little bit more straightforward than the other one. So do you think that there is a good argument here? And again, this is probably one of those where the judge could have gone either way, but there was a certain way that it could go that, well, but they have argued in a certain, but the judge thought one argument was more reasonable in terms of stability in the law and rewarding the person who has the better argument. But I honestly believe it could have gone either way. So any ideas so far?
Number 4.
Okay.
Three or 4.
Okay.
4.
Okay, so you're all, I'm seeing validity. Let me have a look to see if okay, I'm seeing number 4, I'm seeing number 3. Yeah, it seems to be everybody is saying the covenant is valid. The question will be why it is valid.
I have 2 more 3s. I have another 4.
Uh-huh.
Another 3.
Okay, interesting. Okay, so it's really interesting. You've all dismissed 1 and 2. Yeah, 1, you can't just have the house you want in the world of aesthetic covenants. And number 2, the covenant was not vague. It was quite clear. But this was one of the arguments of who was it? Rue. Rue did argue this covenant is too vague. So it's not enforceable. The judge said, number 3. So the judge said the covenant is clear, and the judge also said that there is a legitimate purpose here in protecting the value of the land. So owners associations can get together and they can make a restrictive covenant. They can write a restrictive covenant into the deed that has the purpose of protecting the value of the land. And that is a public policy purpose that the judge and the government will stand behind. Number 4, yes, we can agree to a term, but if that term contradicts the property law or the judge-made law of the particular state or jurisdiction, then that term would be stricken out of the contract. So just because we agree to it in the terms of property does not mean that it will be valid. Okay, let's pause there for any questions or comments.
Yes, I have an interesting insight on the Russian practice. One of the viewers says that in Russia there is a concept of objects of cultural heritage. The owner of such properties is subject to restrictions related to the use and preservation of such real estate. Do you have a similar concept in the US and the UK? When the state restricts with respect to landmark, cultural landmarks, for example?
Definitely in the UK. So in the UK, they have a grading system. And if you have a grade 1 property, which would be like the Palace of Westminster or, the Buckingham Palace, you are very restricted in what you can do with a property, and you have an obligation to maintain certain parts of the property. You can also have grade 2 property, which would be like a stately home or a building that was built by a famous architect. And again, you're very restricted in what you can do. You have to ask the government permission. You have to upkeep certain areas of the property to a certain standard. So yes, we have something, and I think this is really important. Unfortunately, there's not, in some cases, yes, but in the US and Canada also, sadly, there's more of a demolition type of culture. So it is much harder to get a property protected there. There's a much stronger movement for that in the UK as opposed to the US or Canada. And unfortunately, a lot of really beautiful properties were knocked down, say in the 50s and the 60s, beautiful properties, because there were no laws restricting. And I think that's not the best part of our history, because there were beautiful buildings, turn of the century buildings that are much nicer than the ugly things that were built in the 50s and the 60s, the tower blocks. So that is not the best part of our history, but in the UK, definitely. And especially in modern times. Any other questions?
I have an interesting comment which says that in Russia, the viewer is not sure it works. I believe he or she means aesthetic covenant, because it's an agreement. It's not a rule of law. So probably she or he means this.
Okay. So
because in Russia it follows from law.
Okay. Yes. So you can have you can have obligations following from law in the UK and the US too, as well as aesthetic covenants in your deed. So you can have obligations that are imposed on you by the state, as you do in Russia, because you have so many wonderful treasures there. And I'm glad that they do that. But the person, the grantor, the original grantor, can also limit you in terms of other aspects of the property. Again, I'll give my building as an example. in my building, everyone is required to have the same door. So all the doors are the same. You cannot take your door to your flat off and put a different color of door, put different wood in the door, change the door in any way. That is an aesthetic covenant. And the idea is if all the flat doors are the same, the property will be at a higher value.
Thank you. I'm sorry to mention that it is him or her, because I'm not sure if it's a real name or a nickname. I apologize.
No worries.
Mention he or her. Okay. I have a question from Telegram. For avoidance of doubt, is aesthetic covenant still a restrictive covenant, or is it a different type of covenant?
It is a subset of a restrictive covenant. Okay, so it is one example of. So we could have all sorts of restrictive covenants. We could have, and talk about, but aesthetic, it gives it away. It is one type of restrictive covenant that you will find in your deed. And you can have restrictive covenants on some things and some aesthetic covenants, and there's no maximum in terms of a deed. Your deed could be full of aesthetic and restrictive covenant, restrictive covenants, including aesthetic covenants.
I believe the question comes from the fact that you didn't use this 3-step test. Maybe this is the trigger for the question.
Okay, so notice here, and I'm glad that's excellent here. It's excellent, Sergey. So remember, the 3-step test is New York. This is something specific to New York property law. Okay. This case was from Colorado. Okay. And they actually may not have that test. So Colorado has its own property laws and its own case law that defines the test. In this particular case, it looks like we would have to do research, obviously. There are different criteria in Colorado for dealing with restrictive covenants. This is why, if you had a situation with a restrictive covenant and you didn't know whether it was valid or not, you would have to go to the particular jurisdiction. You would have to search in the property law of Colorado, the regulations of Colorado, and the case law about restrictive covenants to see what the criteria were. So that's an excellent point, and it's important for us, again, to start thinking about how localized and particularized property law is, which is what makes it exciting and complex at the same time.
I have a question on YouTube. Does it concern Windows? I believe I'm a little late with this question. I'm not sure what it relates to. Maybe it relates to your example with the doors, or maybe it relates to the this specific case.
Okay. So Windows can also have a restrictive covenant. And again, if we look at my building, it was built in the 1930s, and it has a certain type of windows. Anybody who owns a flat here cannot just go put in what type of windows they want. They have to put in a certain type of windows so that all of the windows, if you look at the flat, look the same. So there are restrictions on the type of windows if you're changing your windows that you can use. So a restrictive covenant can, in this particular case, it is a restrictive covenant and also an aesthetic covenant at the same time, because it's about the look of the building.
Thank you. Another question is, how do you deal with all this huge different state law and case law?
Well, what you tend to, first you take an aspirin, and then you have a headache, you take an aspirin. But no, so the idea is, especially in the US, you pick a state where you want to be a lawyer, okay, and you learn the law of that state. This is why it's very challenging to move from one state to another, especially if you're dealing in an area where state law and state precedents are very important, like contract law, tort law, any of these areas where common law dictates and judge-made law dictates what the precedents are. So, lawyers will pick a state and they will do the bar in that state. And remember, if you have not done the bar exam in the state, you cannot practice in that state. You have to go to the other state. If you move from New York to Pennsylvania, you have to do the Pennsylvania bar. Now, there were some ways where you can get around. If you've done a harder bar, you can do parts of the bar. There's some sort of let's see, ways where you don't have to do the whole bar again. But usually lawyers pick a state and they become an expert in a type of law in that state, so they don't have to go to another place and learn law. So that's how we deal with it.
I have a question related to the same topic on Telegram. Do you have similar cases in other states which are applicable in other states which do not have the same case law? I believe this is about such concept as persuasive cases, which are not directly applicable but are available in other states.
Okay, that's a very good point. Whoever asked that question, and thank you for elaborating, Sergey. So, and we will learn about this. Actually, we will learn about this in the hierarchy of authority, which is one of my favorite things to talk about, which is our last webinar. The short answer is we have to look to the law of our state, and if there is nothing in the law books about this particular issue, then we can look to the cases of other states. And we will have a whole webinar on this very, very interesting topic in a month's time. Okay, so thank you for all those wonderful questions. You've kept up. You're fabulous. You've dealt with all the naughty topics. You deserve a nice cup of tea or whatever you would like to have after this webinar. Let's close off, and I'd like you to write down what your most memorable word was from this session. Okay, and if you're following the presentation, please write down the word. I'm always interested to see what people remember the most, or the word that is new and exciting and has made the most impact on this session. So, Sergey, what was your most memorable word from this session?
For me, tracts, probably. I don't often encounter it in the English language texts.
Okay, yeah, a tract of land, a tract of land. That's a very good collocation, words that go together, to remember, because we would often talk about a tract of land, especially if we're purchasing just land, rather land with a building on it. So that's a good word to add to your legal English vocabulary. Any other words which people they're exciting, difficult, challenging, fun?
Covenant.
Good.
Conveyance chain.
Yes, that's a nice one.
Aesthetic covenant. Injunction. Restrictive covenant. Privity.
Yeah, privity is a word that you'll find in a lot of situations where you have some sort of contract. So that's a nice word to learn and to try to use. And it sounds very lawyerly. There's no privity of estate, or there's no privity of contract in this case.
Lien, restrictive covenants, judicial sale.
Yeah, that's also important to know that concept. The idea that, if your debts mount too much, that your house or your flat could be, or your apartment could be taken away. I'm seeing injunction, I'm seeing aesthetic covenant, I'm seeing restrictive covenant. Yeah, and you know, this is what complicates the sale of a property, because you would think if you buy a property, you can do anything you want to it, but you really, really have to read the property deed, very carefully to make sure that you will do nothing to violate the restrictive covenants that the previous grantor and grantee have written down in the original deed.
And as I know, they are more widely spread in condos than in private houses. That's why US citizens prefer to buy their own home because
Yes.
there are less restrictions and less fees.
Yes, that is correct, Sergey, because the idea, if we're in a condo or an apartment, we have to keep it uniform. And this is the idea of the property value go down if everybody would use their own door, use their own windows. But the house is a little bit more flexible in terms of, this is my property and I'm entitled to paint it the color I want, to use the windows that I want. So yeah, usually I would say it seems that the dream of many people in the world is to have their own house so they could do exactly what they want with their property. Okay, so I think let's wrap up here. And I just want to preview what we're doing for the next month. So our last 2 webinars, this is number 4 of 6. I want to thank everybody again. I'm always impressed by the high level of discussion and participation that we have in these webinars. And that is a credit to you for taking interest in these very naughty legal topics. Our next...
I see a lot of hearts and thank yous on YouTube and Telegram.
Thank you all. It's always...
And thank you also from me.
Thank you,
It was
Sergey.
an enjoyable evening.
Yes, and I would like to refer you to the next session, okay, because we're moving on from property, even though I could talk about property all day long. It's on April 3rd, and we're going to be dealing with civil procedure, which is really exciting. What the journey of the case through the courts, and we're talking about a court case dealing with contracts. So thank you so much, Sergey. Thank you, everyone. And we'll see you in 2 weeks' time to move on to civil procedure.
Thank you for the marvelous evening and session. See you in 2 weeks.